Thank you for joining me. Today we are going to take a deep dive into the drama that has unfolded between Joe Jonas and Sophie Turner in their divorce and custody battle. First, a little bit about me. I am a New York attorney practicing for over a decade. We focus on immigration and family law. I have specific expertise in international child abduction cases. And the purpose of today's presentation is to hopefully provide some useful information about an issue that is a growing concern due to the fact that so many people these days have parents who are from different countries. So let's take a look at the facts. Joe Jonas and Sophie Turner were married in 2019. They have 2 children together, born in 2020 and 2022. For the past year, really not just the past year, since the children were born, the children never really resided in one place for a significant period of time due to the parties' professions. On August 15th, 2023, Jonas and Turner got into a fight. September 1st, Jonas files for a divorce in Florida. September 5th, Turner alleges that she finds out about the divorce on social media. This will become important in a little. On September 20th, Turner files a lawsuit against Jonas claiming that he wrongfully is withholding the children from her in the New York Federal District Court. And on October 2nd, the New York Federal District Court orders that the children remain in the jurisdiction of the Southern District and the Eastern District of New York while these proceedings are pending. And that basically means New York City, Rockland County, where I grew up, Westchester, and Long Island. Kids are currently with Turner in New York City at Taylor Swift's townhouse, and Jonas is seeing them as well. And prior to the split, allegedly the parties had a shared intent to relocate to England. And the reason their kids were here in the U.S. is Turner had some demanding movie or film schedule, and Jonas is on tour right now, but he's available during the day. So the agreement in August was, before the fight, you take the kids, and on September 20th, when I'll go to the States, pick up the kids and their passports, and then fly back to England. And she was supposed to have been back for September 28th, where she had another employment opportunity. I don't know, film. I don't know what she had, but essentially that was the plan. Jonas returned the kids on the 20th, but did not return the kids' passports, so she could not go back to the UK. And I do believe the kids are citizens of both the UK and the US, but they were born in the US. So let's take a look at the laws that apply here. The first is the Hague Convention Against Child Abduction. This is an international treaty, and it only applies in very limited circumstances. First and foremost, the other country that's involved has to be a signatory to the convention. I believe there are a little over 90 countries right now that have signed on to the convention. If your child is taken to or from a country that's not a signatory, unfortunately, you cannot use this law. There are other means, but it is very difficult sometimes, unless the parent gives a child voluntarily, to get a child back from or send a child back to a non-Hague country. And it only applies if the child is under the age of 16, the child has been wrongfully removed or retained by someone, usually the other parent. And what wrongfully retained means is, I say to you, you can have a visit for a month with our child, and I'm going to come back, and then I'm going to take the children back on September 20th. And then September 20th rolls around and the other parent says, no, I don't want to give the kids back. That's wrongfully retaining, as opposed to the parent just taking the child without permission. It also has to be in breach of a parent's rights. So if you don't have custody, or it's not if you don't, well, there's no custody agreements in place, which I'll get to in a second. But essentially, you have to have the parental rights and be exercising those parental rights when the child is wrongfully withheld or removed from you. The other thing I was just alluding to was that there cannot be an initial custody determination. So there's no court of law in any country or state that has made any type of custody order or entered any agreement that you may have entered into regarding custody of the children at issue, even a temporary order. So very limited circumstances. The next law is the UCCJEA, or the Uniform Child Custody Jurisdiction and Enforcement Act. This is a federal law. Now, custody is a state law issue. So what the UCCJEA is a model law. Essentially, because custody is a state law and because you can freely cross state lines, you run into problems when all the laws are drastically different, or if one person goes to another state to try to get jurisdiction in that state and the other parent says, but we lived here our whole lives, type of thing. The UCCJEA basically sets out a procedure to deal with the model laws. All 50 states have adopted with the custody laws. All 50 states have adopted some version of the model laws. New York, for example, is almost word for word. Connecticut, I have a case there right now. There's some slight differences in the language, and every state's a little bit different, but for the most part, they've adopted a very close version of it. And it talks about which courts can hear the case, what they do when there's no custody determination, what they do when there is a custody determination. Another important thing is it treats foreign countries, whether this has nothing to do with the Hague Convention, but it treats all foreign countries as a sister state. So if you have a child custody order from another country, you can register and enforce it in the U.S. or in New York as if it were an order from New Jersey, for example. The UCCJEA says that the home state of the child, which is very similar to what the Hague calls habitual residence, is where the child has lived for at least 6 months prior to filing the application with the court. This does not include temporary absences. So let's say you've lived in New York exactly 6 months, but 3 months ago you took a 1-week vacation with your children somewhere outside the state of New York. That 1 week will not break the 6 months of continuous presence in the state. So you wouldn't have to wait an extra week to file, or not even extra week, you wouldn't have to start over from the time you took a vacation for those 6 months, you would have the 6 months. If the child has not lived in one state for 6 months or more prior to filing the application, then the court looks at significant connections. So the child's significant connections to the state or states at issue. And this is a totality of the circumstances approach, which means there's not one factor that is going to be conclusive. We take a look at everything. We take a look at if the kids are school age or nursery school age, where they go to school, where their friends are, where their family are, where they go to their regular doctors and dentists. There's no list of factors that you have to have or that you can't have. It's fact dependent, so it's a case-by-case approach. There are a few other jurisdiction provisions I'm not going to get into right now under the UCCJEA because it gets very complicated, but the last one I wanted to mention is temporary emergency jurisdiction, and this applies when it isn't clear which state has jurisdiction, or we're claiming that one place has jurisdiction and the kids are in another place, and we're asking that place to make a temporary custody order because the children were being wrongfully withheld or there's some type of unjustifiable conduct, and basically saying, look, the kids, for example, should go to mom in New Jersey, but they're with dad in New York, and the court in New York shouldn't have jurisdiction, so because dad is holding on to the kids in New York, so the court were saying, please enter in order to give mom temporary custody and declare that New Jersey is the home state. Even more exciting law. Florida law comes into play. Why? Because Jonas filed for a divorce there. Florida has adopted a version of the UCCJEA. I am not a licensed attorney in Florida, but I did take a look at what was going on down there. 6 months in Florida is also gives you home state jurisdiction. So the child lived in the jurisdiction for 6 months or more prior to the proceedings. All of the pleadings and the court documents in the divorce filed by Jonas are confidential. That's because he filed in family court down there. So I read all of Turner's pleadings. I could not read Jonas's pleadings. I read a bunch of articles and stuff, and I will caution you, be very careful what you read online. Take it with a grain of salt, as I did, because you can't actually, unless you have an insider track, someone that's going to give you the paperwork. Essentially, it's all confidential. And then finally, we have foreign law. And again, not a lawyer in England or Wales, but when you're dealing with international child abduction cases, you have to learn the law of the foreign country to the extent that you can. You at least have to have an idea of what it is. So in this case, we're dealing with English and Welsh law. And it says that very similar to the U.S. Mom and dad have equal rights to the child, and restricting one parent from seeing their child is considered harmful. So what is Sophie Turner's position? Well, she says that England is the children's home state or state of habitual residence. And she says this because since there's no custody order, both parents have joint parental rights, and that prior to them splitting up and prior to her sending the children with Jonas over the summer, the parties had a shared intent to settle in the UK. In fact, she says that a year ago they sold their place in Miami, and they entered into a contract for a house in England that's supposed to close in December, so they already paid a deposit. Then she also looks at the kids, or points to the kids' significant connections, like saying that the older daughter attended nursery school in England. She also attended the Playbox Theater Company for some acting classes. She claims that the kids' regular doctors and dentists are there. Of course, family members, but obviously Jonas being American and his family members are here, he has that same argument. The big thing that she's really saying is that, because you may be thinking, Amanda, you just said the kids are with Turner in New York, so how is she saying the kids are being wrongfully retained by Jonas? That's a great question. Thanks for asking. The reason is because Jonas will not return the passports of the children to Turner, so she can't return to England. So that's what her claim is. And she's saying that because of that, her rights to custody are violated, because she's looking at a choice of, do I leave the kids with Jonas and go back to England, or do I give up the job that I had and wait here in the U.S. until I'm given permission to go back with the kids, or Jonas is ordered to give the passports back. Now let's look at Joe's position. He is saying that Florida is the home state of the children. He claims, now this, without reading it, this is a claim that has to be made in order to start the case. He claims the kids have resided in Florida for at least 6 months prior to September 1st when he filed for divorce. He also claims that Turner knew about the divorce prior to seeing it on social media. The reason that this is important is because in Florida, New York doesn't have this type of automatic order. Connecticut does. But in Florida, if once you file for divorce, there's an automatic order that says you cannot remove the child from the jurisdiction. So Jonas is claiming that by giving Turner the passports, he is violating a Florida court order. And that's why he won't give the passports. Now this, you might be thinking, but wait, I thought they were in New York right now, not in Florida. And didn't Jonas return them to her in New York? And you would be correct. They are in New York with her right now, so they technically did remove the kids from the jurisdiction. That order has been stayed by the Florida court because of the lawsuit in New York. So that is why New York entered the order that the kids can't leave that jurisdiction or this where I am. And that is actually a neutral order, meaning by keeping the kids in New York where neither party is claiming there's jurisdiction over custody, it's not giving anyone a leg up because these cases can drag on, and then sometimes it can give one parent more of an argument that the kids are more settled. So if the kids went back to England, started nursery school or whatnot, then they, Turner can point to that, and same goes with Florida. So it is a bit of a neutral forum. And then, as I said before, the Florida court documents, you can see what the docket or what's happening in the case, like each event, but you cannot actually read the court documents. Welcome back. If you notice, I look a little different. We've had some technical difficulties when I was recording earlier, so fingers crossed that this works. So on to our legal analysis. This is a story of jurisdiction. Jurisdiction is a complex issue. In law school, our first year, we take a full year of civil procedure and focus a lot on jurisdiction. In this case, we are dealing with really that's the main issue. Which court should hear the case? Both parties in this case have made some strategic filings. Jonas, he filed in Florida to be the first one who files. That can have some advantages. He claimed it based on the fact that they previously owned the house there and claimed they lived there for 6 months. Turner filed her suit in the federal district court in the Southern District of New York. And as opposed to Jonas's filing, this is public. Jonas filed in family court, so everything is confidential and private, which is why I haven't been able to read all of his pleadings. Whereas by filing in the federal court, Sophie Turner made everything public, which puts pressure on Jonas. Does the Hague Convention apply? Well, it doesn't apply if the parent acquiesced to the other parent taking or retaining the child. And it did not apply in this case, at least until September 20th. It also doesn't apply if you're actually with the children. So if what they call the left behind parent is with the children. And ever since Turner came to the U.S. to pick up the kids, she was able to pick up the kids. She just wasn't able to get the passports back. And the typical case that you have is that one parent is trying to get the kids back. So in this case, I do not think the Hague will apply because the Hague does not apply to passports. We may never find out if this doesn't go to trial, or if the judge doesn't decide. We're never going to find out, essentially. And if it doesn't apply, the case should be dismissed. If I were Jonas's attorneys, I would have filed a motion to dismiss already. But the parties are trying to mediate, which we'll get to shortly. If it does apply, if I'm wrong and it applies, or Turner puts in the UCCJEA, then there will be the same jurisdictional analysis used. They're going to first determine the home state or the place of habitual residence of the children. And again, since I can't access Jonas's facts, I don't know what he claimed about where the kids reside in the last 6 months. I assume it's Florida. If the kids were in England from April to August and were supposed to return to England permanently after that, then I do think England will be the home state. And so, according to Sophie Turner's facts, which are the only ones I've been able to read personally, it does sound like England should be the home state. It all based on their significant connections, because it doesn't seem like they have 6 months anywhere in particular, unless England will be considered that as their break from being in England as a temporary absence. But they do have significant connections. The nursery school the older child went to, the what was it called, Playbox Theater family is there. Obviously, there's family in the U.S. as well. And since there's fortunately no abuse allegations, then and the children aren't currently separated from Turner, there's no temporary emergency jurisdiction. So to be clear, New York will not be deciding who will have custody. All New York will be deciding is which court, Florida or England, should make that determination. And the Florida court order has been stayed, and that was the order that said that children cannot be removed from Florida without the consent of court. But obviously that was put into play and the children were removed from Florida, which is what makes Jonas's argument that he can't give the passports because of the Florida court order a little strange. So what are my projections for the New York case based on the Hague Convention? Unless Sophie Turner, they amend their pleadings and add in the UCCJEA, or they end up settling. I do think Jonas would win on this because it shouldn't apply in this case. When it comes to if U.S., meaning Florida or England, should have jurisdiction over the custody determination, I do believe that based on the facts we have, that Turner will win that one. So let's look at our key takeaways. International child abduction is complex. It involves the intersection of multiple state laws, federal laws, international treaties, and foreign law. And it really only applies in very limited circumstances. And it's important, and this is why it's important when you're filing any type of claim in court, that you include every single law, every single claim that could possibly be relevant to avoid dismissal. Because again, if I was Jonas's attorney, that would have been the first thing that I did, was file a motion to dismiss. Who will prevail? As I just said, I think Jonas will in New York. Habitual residence will be decided by New York, so they'll say either Florida or England. And Turner's going to be able to get the children's passports without the Hague Convention. She, in fact, could have gotten them without all of this going on. They are dual citizens. There is ways to get travel documents or a duplicate passport when you're in a situation this way. So let's look at some case updates. Hopefully this isn't outdated by the time I release this video due to my technical difficulties last week. So last week, the parties engaged in 4 days of intense mediation. And I'm going to go over, and it says starting today. This is a little late, the slide now. It actually started a week ago today. I'll go over the difference between mediation and litigation shortly. In the Florida court, there was a motion to dismiss filed by Turner. I'm assuming, again, I can't access the documents. I'm assuming she's claiming that the Florida court does not have jurisdiction because the kids were not living in Florida for at least 6 months prior to the filing of the divorce. And she also did file for divorce in the UK. Again, those documents I don't have access to. In New York, they have a trial scheduled for January 2nd, 2024. Obviously, if their mediation was successful, I'll provide an update, then there won't be a trial court, or there won't be a trial, I should say. There'll be a trial court. There won't be a trial on January 2nd. If there is, it will be about, like I said, just the question of should Florida or England decide the issue of custody. The kids are going to remain in New York until then, and both parties have unfettered access to the kids, and I believe they are still at Taylor Swift's townhouse in the city, which I heard has a full Olympic-sized pool. I think that was the townhouse that has it. So not a bad place to wait around. So what is the difference between litigation and mediation? Why does it matter that they're doing this? Well, there's some very key differences that people don't know. Litigation is an adversarial process, whereas mediation is a non-adversarial process. But basically what that means is that mediation, the goal is to find common ground, is to reach a settlement, reach an agreement, whereas in litigation, you're trying to win. You're trying to beat the other side, and it can be a lot more hostile. Litigation, you have a judge, and mediation, you have a neutral third-party mediator. What is the difference? Well, a neutral third-party mediator is somebody that you hire, that both sides agree upon. It's someone who they're working with both sides, not advocating for one side or the other, but working with both sides to come to an agreement. Whereas the judge, although the judge encourages you to come to an agreement pretty much in every case, what the judge doesn't do is they don't advocate for one side or another, but they're also going, if you can't make a decision or if you can't come to an agreement with the other side, the judge is going to be the ultimate one to make this decision. With the neutral third party mediator, you two don't come to a decision, then you're going to litigation. So that person never has to be the one making the actual decision. In litigation, you're going to have multiple court appearances. Mediation is not in court at all. You might have to go to court one time after to enter the settlement agreement on the record, but you go to just a regular office. You sit down with, both sides can bring attorneys and third-party mediator, and you just hash it out until you get an agreement. Whereas litigation, you're going back and forth to court. You can enter into an agreement there too, but you got to check in with the judge all the time. Litigation's involuntary, while mediation is voluntary. You don't have to engage in mediation. You could say no. If your ex files a divorce against you, a child custody case against you, whatever it is in court, and you don't go, you're going to get a default order. You're going to automatically lose. With mediation, you could say no and just go to litigation. So it's up to you. But if someone files something against you and it's a valid filing, you have to deal with it, or you create more problems for yourself. Litigation is very expensive, while mediation is less expensive. I will say 4 days of intensive mediation is not going to be cheap. Hopefully it works, because if it doesn't, that's the other thing that can make mediation expensive. Mediation doesn't work, you're going to litigation anyway. So you want to be confident that you have a good chance of reaching an agreement with your ex or the child parent, parent of your other parent of your child, whatever the case may be. Mediation isn't for everyone, so you want to go over that carefully. And then finally, litigation tends to take a long time, whereas mediation can be very quick, because litigation, you're at the mercy of the court schedule. You might want to come back next week, but the court might not have a spot for you for 3 more months. Whereas mediation, as with this case in particular, you can pick the dates yourself when you, the other side, and the mediator, and possibly your attorneys are available. Okay. That is all for today. If you found this helpful, spent a long time on this, so like, comment, share, save. I will provide an update as soon as I have one. I probably will find one today and do a little quick one. I hope that this deep dive into the issues really was helpful, because it is really complex. And as I said at the very beginning, I think this is incredibly important to talk about, because the accounts of international child abductions has steadily increased over the years due to the ability to travel has become much easier. If you need legal help, if you have a similar situation where your child was wrongfully retained or taken from you, or you're being accused of that, or you need divorce, family law, or immigration help, we're here for you. Contact information's on your screen. More than happy to help. And, like I said, make sure to like us and follow us so that you don't miss any of our videos. Thanks for watching, and have a great day.